slide you see that I use the term orphan works, but indeed there is no such a legal term in Polish law. Orphan works are used by the doctrine, by the literature, but they have not been defined in law. The doctrine indicates that mainly two categories of works can be categorized as orphan works. These are works where copyright or personal rights holder is unknown, and the second one, in case when a contact with such a rights holder is very difficult or even impossible to establish. Another rule of Polish law, and I'm sure not only Polish law, is this principle that for each use there is an obligation to pay remuneration to the rights holder. There are some exceptions when this burden of remuneration is shifted to other categories of users or other participants of the commercial use, but normally the user is the one who is obliged to pay. And so this is the other, we see it as another side of the problem with orphan works, that to be able to pay the remuneration to the author when it's not possible to contact him or to know who it is. And the other issue, which is, I think, interesting, although not very positive commercially in Poland, is that the obligation to pay for the use goes beyond the copyright protection, which means that even works which are in the public domain are subject, their use is subject to payment. There is a fund in Poland for the support of creative activities, and public producers and publishers are obliged to pay between 5 and 8% of the price of work for the use. It's called the domain public payment doctrine. Possible solutions, we have mentioned many today. Some of the, we could say that one of the possibilities would be that collective copyright societies would participate in granting licenses, in collecting fees to be given to rights holders. Special license, statutory license, is also one of the solutions. In terms of licensing, use of Creative Commons type of license, which is known and is public. Also, digital rights management. This is a clear, very important tool in managing intellectual property, and also creating a database, which was mentioned. We just like picked up some solutions, which probably neither of them represents the only solution. They probably could together maybe build up a system that could provide solution to the problem.
In terms of solving the orphan works problem, do you see that as a possible mechanism, in the sense that you already have a payment which obviously must go beyond the line of copyright, or is that a hindrance?
In Poland, we see it as a hindrance, and our clients who are users of content are not very happy about having to pay to the public domain. I would say that this responds to the part of the payment part of orphan works. But the other question which arises is that, are you supposed to pay for not copyright protected works in the first place? And in this case, you do pay for them. So if you think that the copyright expired, and this is a public domain work, maybe you should not be obliged to pay for the use anymore.
Yeah, nonetheless, it would seem, it would provide a payment stream for works which not only fell outside copyright, but obviously were in copyright, but the owner couldn't be found. So in a sense, you would be paying money to someone for something. But yeah.
Sorry, briefly, I'd just like to question this public domain payment, whether or not that is paid regardless of whether a fee has been paid to an owner of a picture, like a picture library, for instance. And then secondly, I'd just like to ask you, what exactly is educational use deemed to be under Polish law, and when does that stop? For instance, we would regard perhaps a textbook use as being a commercial use from our perspective in terms of supplying someone with a picture.
As to address your first question, I think that this fee is being paid regardless of the license fee, and but surely if you have a license for this period of certain time, you just have it for this time, and when you want to still use it, and this falls in time when the work is under public domain, and you just pay again in a way. As to the second question, scientific use, educational use excludes commercial use. So the scientific use is supposed to educational use is for schools, for instance, at universities. Scientific is for conducting searches, preparing some studies. So surely it can be divided from commercial use by commercial interest in it, and the profit factor that should be lacking in scientific use. Thank you.
Thanks very much.